Welcome to LexiCast, a podcast designed to help you grow in your legal practice, with weekly updates on current topics, trends, and practical insights. Perfect for listening on the go. Let's dive in.
You know, we've all had that specific moment with a client.
Oh, absolutely.
They're comfortable in your office, maybe a little too comfortable, and they just drop a piece of information that makes your stomach instantly turn.
Yeah, and it's not always, a traumatic confession to a murder or something.
Right. Sometimes it's just, I'm hiding some assets from my spouse.
Or we're completely ignoring that safety regulation just to hit the Q3 target.
Exactly. And in that split second, you aren't just their lawyer anymore. You are a vault.
And that is really the ultimate lawyer's paradox, isn't it? I mean, we are paid to extract every single detail from a client.
To know them better than they know themselves.
Right. But at the same time, we're professionally crippled by the inability to share any of it. It's the silence that actually binds the whole profession together.
It is. And today, we're looking at the actual mechanics of that silence. We're doing a deep dive into the silent retainer.
Based on some really excellent speaking notes from Amy Castos.
Yes, her notes on confidentiality, specifically focusing on the Australian Solicitors Conduct Rules, the ASCR 2015.
Now, before anyone listening reaches for the skip button because they think, oh, confidentiality, that's just Law 101.
Let's be clear, we aren't talking about the absolute basics here.
No, we're assuming you already know not to gossip about your active cases at the pub.
We are interested in the edge cases today. The mission for this deep dive is to get into the gray zones.
The highly specific statutory interpretations of words like imminent versus probable.
Yeah, and the absolute nightmares of Rules 9.1 and 9.2, where keeping your mouth shut might actually stop being ethical and start making you an accomplice.
Because as the source material points out, the difference between a compliant lawyer and a defendant in a disciplinary tribunal often comes down to just how you define a single word.
It really does. So let's start with the scope of the vault. Rule 9.1. It sets up what's essentially a triple lock on the client's secrets.
Right. You've got the mix of contract law, so the implied term in your retainer.
Then equity, the fiduciary relationship.
And finally, the professional rules themselves.
But playing devil's advocate for a second, isn't that a bit overkill? Why do we need 3 separate legal mechanisms just to say, keep a secret?
Well, because the whole justice system collapses without it. It's entirely about encouraging full and frank disclosure.
Making them feel safe.
Exactly.
Yeah.
If a client thinks there's even a tiny chance, like a 1% chance, or loophole where you might disclose their secrets to the police or a competitor, they will hold back.
And if they hold back, you're trying to give advice based on an incomplete map.
You simply cannot defend what you don't know.
Yeah.
So the strictness of the duty is critical. It incentivizes them to just dump all their baggage right on your desk.
And baggage is the perfect word for it, because what actually counts as confidential, the notes highlight this phrase I really love, the getting to know you factor.
That is a great phrase. It sounds so harmless.
It sounds like a first date, but it's actually a massive liability trap for us.
It really is.
Because confidentiality isn't just the legal file or the contracts. It includes texts, voicemails, their financial position,
Competitor pricing models, business strategies, even intimate knowledge of their character or personal habits.
So if I'm representing a CEO and I figure out during our meetings that he has a really short temper or he uses a specific tactic to manipulate negotiations, that is confidential.
Yes. If you acquired that knowledge during the engagement, it counts. The source gives a brilliant example of a property lawyer to illustrate this.
Right, the conveyancing example.
Yeah, so you're acting on a standard property matter.
Yeah.
Very administrative. But during a meeting, the client just breaks down and confesses to a crime that has absolutely nothing to do with the house.
Just completely out of left field.
Exactly. And the instinct is to think, well, I'm a property lawyer. I'm not his criminal defense attorney. This is outside my retainer.
But it doesn't matter, does it?
Not at all. Rule 9.1 does not care about your specific practice area. You acquired that information while acting as their lawyer. So into the vault it goes.
Which brings up the duration of this duty. The notes are very clear that it is indefinite.
Indefinite. It survives the end of the retainer, and it even survives the client.
But practically speaking, how does that play out? Say my client dies, I've got the file. The executor of the estate comes to my office and says, "Hi, hand over everything."
Right.
Am I supposed to just stonewall the person trying to administer the estate?
Well, this is a classic trap where lawyers get into trouble.
Yeah.
You cannot just hand over the entire file because the executor asked for it.
Even though they step into the client's shoes?
Yes, because the notes specify that your file notes your personal observations. Those belong to the practice, not the client.
Oh, that's an important distinction.
You provide the documents necessary for the executor to do their job, but you are still the gatekeeper of the deceased's secrets. You don't hand over those getting-to-know-you factors.
So even after they pass away, their reputation is essentially still in your hands.
Especially then, because they aren't around to defend themselves anymore.
Okay, so the vault is incredibly tight. But I want to make sure we distinguish this from privilege, because I hear lawyers use confidentiality and legal professional privilege interchangeably all the time.
Oh, constantly. But they're very different concepts.
How so?
Think of it this way. Confidentiality is the broad ethical duty. It's the gag order you wear every day. Privilege is much narrower. It's a substantive right of the client to resist disclosure in legal proceedings.
So all privileged information is confidential, but not all confidential information is privileged.
Spot on.
Can you give me a real-world scenario where that distinction actually matters?
Sure. Let's say you get a subpoena, or the statutory regulator issues a notice to produce documents.
Okay.
If the information they want is subject to legal professional privilege, you can use that as an evidentiary shield to resist handing it over.
Because privilege is a right.
Exactly. But if the information is merely confidential and doesn't meet the strict test for privilege,
Then you have to hand it over.
yes, confidentiality folds when the law compels you. Privilege puts up a fight.
That makes total sense. Now let's escalate this a bit. We've talked about the duty to the client, but the source material is emphatic about the hierarchy of duties. The duty to the court and the administration of justice is paramount.
Always paramount. It trumps confidentiality every time.
So if acting in my client's best interest requires me to mislead a judge,
You can't do it. The duty to the court wins. If your client is going to commit perjury, you might actually have to disclose confidential information to avoid misleading the court, or you have to withdraw from the case entirely.
which perfectly transitions us into the really messy part of the notes. Rule 9.2.
The escape hatches.
Right. Rule 9.1 says shut up, but Rule 9.2 says speak up.
But you have to be so careful here. The notes frame these exceptions around a very specific standard. The reasonably competent lawyer.
I found that standard fascinating.
It is, because you don't just use an exception because you feel morally obligated to. You have to be able to justify that a reasonably competent lawyer in your exact shoes would have made the same call.
It's the ultimate peer review test. So we had the standard exceptions. 9.2.1 is client authorization. Obviously get that in writing and advise them on the risks.
Always in writing.
Then 9.2.2 is when you're compelled by law, like we just discussed with subpoenas or trust account irregularities.
And 9.2.3 is self-defense. If you need to seek advice from an ethics committee or defend yourself against a disciplinary complaint or a negligence claim, you can open the vault.
But I want to spend our time on the dangerous exceptions. The deep dive material highlights rules 9.2.4 and 9.2.5.
The future crime and the physical harm exceptions. This is where it gets incredibly tricky.
Let's break down 9.2.4 first. The rule allows disclosure, quote, to avoid the probable commission of a serious criminal offense.
And this is where statutory interpretation becomes your best friend or your worst enemy.
Let's parse the words probable. In everyday conversation, I might use that to mean it could happen.
But legally, it has to be much firmer than a suspicion. The notes define probable as more likely than not.
Greater than 50% odds.
Yes. You have to look at the facts objectively and say, the odds are they are going to do this. It can't just be, my client is angry and might do something stupid.
Okay, what about the word serious? If my client says he's going to drive home from our meeting and he's visibly intoxicated, is that a serious criminal offense?
Under the strict reading of this rule, probably not. The source material points us directly to the Crimes Act. A serious offense generally means an indictable offense.
An indictable offense.
Right.
So practically speaking, I'm sitting in a meeting, a client makes a threat, and I literally have to mentally check if that specific threat meets the threshold of an indictable offense in my jurisdiction.
Yes, before you can safely call the police without breaching your ethical duty, you need to know your Crimes Act.
That is an incredibly high bar for a split-second decision under pressure.
It is. Now compare that rigid standard to Rule 9.2.5, the physical harm exception.
Right, this is to avoid imminent, serious physical harm to the client or another person.
The operative word there being imminent.
Which is a temporal standard.
Exactly. It's about time. The notes describe imminent as meaning right about now.
So not tomorrow, not next week.
No. If the client says, I'm going to track him down and break his legs next month, That might be probable, and it's definitely serious physical harm, but it is not imminent.
So if I panic and disclose that threat today, under Rule 9.2.5, I've breached confidentiality.
Technically, yes. You used the wrong key to open the lock.
Let's see how this actually plays out by looking at the case studies provided by Amy Castos. The first one is the Nutex scenario.
Ah, the corporate cover-up.
So the facts are, James is a commercial lawyer representing Nutec in a major merger. During the due diligence, the CEO admits they are hiding massive environmental violations, hazardous waste dumping.
And the CEO tells James they plan to keep hiding it so the deal doesn't collapse.
So James is completely stuck. If he discloses the toxic waste, he breaches confidentiality under Rule 9.1.
But if he stays silent and continues doing the legal work to close the deal, he is misleading the other party under Rule 4.1.2.
He becomes an instrument of the client's fraud.
Exactly. You cannot be complicit. So what are James's options?
Well, the analysis suggests his first step is to advise the client to disclose. Tell the CEO that transparency now avoids a massive lawsuit later.
But assuming the CEO refuses, which they usually do in these hypotheticals,
Then James has to withdraw.
he does. He must avoid being part of the fraud. But how he withdraws is the real dilemma. Does he just quietly resign?
If he quietly resigns, the fraud still happens. The client just hires a new lawyer who doesn't know about the toxic waste, and the buyer still gets scammed.
This brings in Rule 9.2.4. Is the fraud an indictable offense? If it is, James has the option to disclose it to prevent the crime.
But the notes highlight a really terrifying thought here regarding liability.
Yes, the liability of silence.
We're so conditioned to worry about getting sued or disciplined for talking out of turn. But what if James withdraws quietly, says nothing, the merger goes through, and the buyer loses $50 million because of the environmental cleanup?
And then the buyer finds out James knew.
Right. Could they sue James? Claiming that he had an ethical gateway to speak up under 9.2.4, he chose to stay silent, and his silence directly aided the fraud.
It's a very real risk. The source material notes that failing to disclose when you could have, and a third party gets harmed, completely shifts your risk analysis. Silence is not always the safe, neutral option.
And sometimes silence is negligence.
Precisely.
Let's look at the second case study. I think this one is even tougher because it involves a child, Tim and Hannah.
The runaway dad scenario.
Hannah represents Tim in a really bitter divorce, and Tim just flat out tells Hannah, I'm taking our child out of the country in a week without the mother's consent.
And the mother suspects something is up. Her lawyer actually contacts Hannah and asks for confirmation.
Now, Hannah is a human being. She wants to stop a kidnapping. But she's a lawyer first, so she looks at Rule 9.2.5, the physical harm exception.
Let's apply the statutory interpretation we just discussed. Is the harm imminent?
No, because he said he's doing it in a week. It's not right about now.
Okay, is it serious physical harm?
Again, hard to verify. Taking a child on an airplane isn't inherently causing physical harm, even if it's psychologically devastating and entirely illegal.
Right, so if Hannah calls the authorities relying on the physical harm exception, she fails the test.
Which means Tim could file a disciplinary complaint against her for breaching confidentiality, and he might actually win.
He very well might.
Mm-hmm.
But that's why Hannah needs to look at Rule 9.2.4 instead, the future crime exception.
Let's run that test. Is kidnapping or child abduction a serious criminal offense?
It is an indictable offense, yes.
Is it probable?
He literally stated his intention to do it, so it is more likely than not.
So 9.2.4 is the stronger, safer path. She can make the disclosure.
Yes. The physical outcome is the same. She calls the police. But the legal scaffolding she builds in her file notes has to be completely different.
It shows how specific wording changes your entire ethical path. She isn't acting to prevent imminent physical harm. She is acting to prevent a probable serious crime.
And that ties right back to the reasonably competent lawyer standard. She needs to write a file note saying, I am disclosing this information under Rule 9.2.4 because the client's stated action constitutes an indictable offense.
That file note is her absolute shield if Tim comes after her later.
Because it proves she didn't just panic and act on moral intuition. She engaged in a technical statutory exercise.
It really reframes confidentiality. It isn't just a passive shield where you sit back and say nothing. It's an active, ongoing risk assessment.
That's a great way to put it. We carry these secrets so the clients don't have to, but we have to know exactly when and how we are legally permitted to drop the bag.
Which brings us to our final thought for the listener. We've gone through the triple lock, the reasonable lawyer standard, the strict definitions. What is the main takeaway you want people to leave with today?
For me, it's that confidentiality is never absolute. It's the bedrock of trust, yes, but it is not an impenetrable shield for client wrongdoing. You have to run the 9.2 checklist in your head the moment a client tells you something shady. Don't wait until the police are literally knocking on your office door to figure out your ethical position.
And I'll add a very specific call to action to build on that. Before your next client meeting, pull up your local legislation and review the exact definition of an indictable offense in your jurisdiction.
That is fantastic advice. It varies by state, it varies by penalty units.
Because as we saw with the runaway dad scenario, knowing the precise technical threshold of that one phrase might be the only thing standing between you keeping a dangerous secret and you having the legal authority to call the police.
It could save a life, and it can save your practicing certificate.
Exactly. Something to mull over on your commute. Thanks for listening to The Deep Dive. See you next time.
That's it for today's episode on LexiCast. If you're looking for more in-depth episodes that can also be claimed as CPD activities, check out our LexiCast CPD Plus page linked in this episode's notes. Follow us now to stay up to date, and we'll see you next time.